asked him what he did, and he said that he just snapped. My baby would not say nothing back to me at all.
Went up to Jackie, sitting in her car, put his gun up to her head through her window, and executed her.
It was like boom, boom, boom. It was like 2 shots, then her body dropping.
Stephen Xaver was responsible for the tragic Sebring Bank incident, which resulted in the loss of 5 lives at a Highlands County bank. On the day of the incident, Xaver entered the Sebring Bank and instructed those inside to lock the doors. The victims, identified as Cynthia Watson, Marisol Lopez, Ana Pignon Williams, Deborah Cook, and Jessica Montague, were present during the ordeal. During the sentencing, Xaver displayed little reaction, while the families of the victims were visibly emotional.
My mom was the person who welcomed you into the bank with a smile, and in return, you forced her to lock the doors of the bank before killing her.
One of the victim's daughters, Kiara Lopez, presented a photograph of herself with her mother, recalling how her mother warmly welcomed customers, but was ultimately caught in the tragic event. Lopez, who was in college then, shared how her home now feels empty and expressed her ongoing struggle to understand what happened.
My childhood home feels empty now. I don't like coming back here to a place that I grew up and loved.
She called out Xaver.
I know you have a lot of hate in you.
Michael Cook, whose wife was among the victims, reflected on the fear they experienced that day.
I can imagine the terror those women felt when the first shot went off, knowing they were next. I think he deserves everything he gets and more. And if they would let me, I'd be the one that would pull the switch.
He believes the sentence is appropriate and hopes for timely justice.
This should not drag on for years and years. It would be a miscarriage of justice if these family members had to wait decades for this sentence to be carried out.
The families of the victims remain determined to see justice served without unnecessary delays. Following the jury's recommendation, Highlands County Judge Angela Sin officially pronounced the death penalty, emphasizing the case's gravity. Joe Timothy Raines, charged in connection with the tragic deaths of Landon Reyes and Monty Burrows, has entered a plea deal in court, initially facing multiple charges, including 2 counts of murder, possession of a weapon, conspiracy, and drug-related offenses. Raines accepted responsibility for his actions. The incident began when Reyes visited Raines's house on South Buncombe Road. According to Raines's attorney, after Reyes left the property, Raines believed that some of his personal belongings, including a cell phone, had been taken. Despite their long-standing friendship, tensions escalated, leading to an eventual confrontation. Later, Raines and Burrows drove to Reyes' residence, where a heated dispute resulted in a tragic altercation. As a consequence, both Reyes and Burrows lost their lives, while Raines sustained severe injuries. In court, emotions ran high as the families of the victims expressed their grief and longing for justice.
17 years we had very cherished memories together. And I'm just glad that I was able to take him fishing and I was able to teach him how to drive a car. And so many tears have been shed. Families have lost a member, brother, a cousin, a nephew, a son, and a friend.
My birthday is January the 12th. I have to live with this every year. Every day I think about this. It's not one day I think about it, after a month I think about it. This is an everyday event for me, for my family. It's a tragic event.
Rey's father and Burrows' brother shared memories of their loved ones and spoke about the irreplaceable void left in their lives. Though no sentence can undo the loss, they believe the court's decision brings a measure of justice.
Is that the defendant be confined to the Department of Corrections for a period of 15 years. The defendant will have credit for the time that he has already served.
Raines pleaded guilty to 1 count of murder and received a 15-year prison sentence with credit for time already served. His attorney emphasized that he had no prior criminal record and chose to accept the plea to avoid a prolonged trial, hoping to provide closure to the grieving families. Joseph Ferlazzo has been found guilty of first-degree murder for the killing of his wife, Emily Jean Schwartz, in Bolton. The incident occurred while the couple was celebrating their wedding anniversary. According to court proceedings, Ferlazzo claimed he acted in self-defense, stating that he feared for his life. During the trial, the jury listened to Ferlazzo's testimony, detailing the events leading up to and following the tragic incident.
All I remember is feeling like 3 was like, I felt like, it was like boom, boom, boom. And it was like 2 shots and then her body like dropping.
Despite his defense, the jury ultimately rejected his claims and delivered a guilty verdict. The courtroom was filled with emotions as the verdict was announced, with Emily Jean Schwartz's friends and family expressing a mixture of relief and sorrow.
The only thing that could make it better really is to have my daughter back in my arms and alive and breathing and singing and loving life the way that she was.
Her mother described the verdict as a step towards justice, acknowledging that nothing could bring her daughter back, but expressing gratitude that accountability had been served. Ferlasso remains in custody without bail and now faces a minimum prison sentence of 35 years, with the possibility of life imprisonment. The official sentencing date has yet to be determined, with the state advocating for the maximum penalty available under the law. The tragic case of Giovanni Mejias began when a boy was found to have died from severe injuries. Authorities ruled out an accident and launched an investigation into the circumstances surrounding his death. Ellis Nelson Ortiz Nieves, his mother's boyfriend, became the primary suspect due to his history of abuse allegations and a lengthy criminal record. Despite previous reports made to law enforcement and child protective services regarding potential abuse, no intervention was made to remove Mejias from his home.
Who did you call?
I've called the cops, have been involved. CPS multiple times have been involved. The school was involved.
Concerns raised by family members and others were hindered by fears of gang affiliations within the household. Ortiz Nieves had a criminal history that included offenses such as drug and charges, car theft, shoplifting, and assault. As a juvenile, he had a record of domestic violence, which led to time served at a youth facility.
I don't know the details of the case. You really just want to talk with your attorney?
During his trial, Ortiz Nieves pleaded not guilty.
So the first count is called felony murder, life without parole. They're alleging you murdered one Giovanni Mejias. It is called felony murder. It is a felony.
But the court found sufficient evidence to convict him of first-degree felony murder and abuse. He was sentenced to life imprisonment without the possibility of parole, along with an additional 80 to 150 years for child abuse. Ortiz Nieves appealed his conviction, citing legal errors and ineffective counsel, but higher courts upheld the ruling. His federal petition challenging the conviction was also denied for lack of merit. The case of Grand Rapids businessman John Dollinger's death began with the arrest of Daniel Thomas and Dejana Keelik. Authorities charged Thomas with murder and Keelik with conspiracy to commit armed robbery. Both suspects were held without bond at the Kent County Jail as the investigation unfolded. Thomas had a prior conviction for robbery and served 15 years in prison before being released. After his release, he faced multiple drug-related offenses but was granted a delayed sentence, allowing him to remain free while proving his commitment to rehabilitation. However, during this period, Dollinger was tragically killed.
He committed or attempted to commit a felony.
Investigators linked Thomas and Keelik to the crime through critical evidence. Dollinger's phone records revealed contact with Keelik prior to the incident. A crucial breakthrough in the investigation came when a bag discovered in a nearby field contained ammunition, documents belonging to both suspects, and Keelik's cell phone. Forensic tests confirmed that the ammunition matched the caliber of a bullet found at the crime scene. Authorities determined robbery to be the primary motive.
So I'm not going to get into details of, what occurred between those three parties or what brought them all together. That's going to be brought out in court.
Come on, that's the meat and potatoes.
It is the meat and potatoes of this case. But there's significant work we're still doing on this case. And to go into those details right now would not be appropriate for me.
During legal proceedings, Keelik's attorney requested bond, but the court denied the request. As the trial progressed, Thomas was found guilty of Dollinger's murder and sentenced to life imprisonment without the possibility of parole. Despite attempts to appeal the conviction, higher courts upheld the original verdict. Keelik, in a plea agreement, admitted to conspiracy to commit armed robbery and testified against Thomas. She was sentenced to time served and 5 years of probation. The tragic case of London Amir began when her mother, Shaniqua Strickland, left her in the care of her former boyfriend, Ricky Whiteside Jr., at the Lazy T Motel on Plainfield Avenue in Grand Rapids, Michigan.
So when I got ready to go to the store, the last words I said to my baby was, I laid her down and I said, okay, good night. Mommy loves you. I'm going to the store and I'll be back. And my daughter said, I love you too, Mommy. And she closed her eyes.
Strickland recalled telling London she loved her before leaving for the store, to which London responded, I love you too, before closing her eyes.
So far as I knew, when I left that room, my daughter was asleep. And then I looked up as I walked in and my daughter was in Ricky's arms. And, you know, as I'm closed, I'm like, you know, what's wrong with her? And he's like, oh, she said, it's hot. So I took her shirt off. But I'm like, no, like something's wrong. And I just start screaming on the phone like I'm talking to my cousin, like my baby is limp in his arms. And he's trying to tell me that my baby is okay, but I know for a fact my baby is not okay. My baby was foaming at the mouth. And she was just passed out like this, just in his arms. And he's trying to hold her up to tell me my baby is breathing. And I know you're not going to tell me my baby is breathing. Something's wrong with my baby. And I was just screaming. And I dropped the phone and picked it up because I was on the phone with my cousin and I called 911.
Okay. Could you tell whether London was conscious at all?
She didn't look like it to me.
Was she responsive to you?
No, and I kept saying her name and kept saying her name, and my baby would not say nothing back to me at all.
Upon returning, Strickland found London unresponsive in Whiteside's arms. Sensing something was wrong, she panicked and called for help. Despite Whiteside's attempts to reassure her that everything was fine, Strickland described the heartbreaking moment when she realized her daughter was not breathing. Following an investigation, authorities determined that London had sustained fatal injuries.
I asked him what he did, and he said that he just snapped. That's what he told me. He just snapped.
Is that all he said?
And his pride wouldn't let him tell the truth. Like I said, when I told her that I was going to the store good night and I love her, she said, love you too, Mommy, and she closed her eyes, and that's when I went out the door. That was the last time I saw my baby alive.
Whiteside later admitted to Strickland that he had just snapped. The severity of the injuries led to his arrest and subsequent charges of felony murder. During the preliminary hearing at the 63rd District Court, Strickland delivered an emotional testimony recounting the sequence of events and the devastating impact of her daughter's loss. After a thorough legal process, Whiteside was convicted and sentenced to life in prison without the possibility of parole. Alex John Radulovich, 23, was entrusted with the care of his girlfriend's son, Alexander Butler, when a tragic incident occurred. According to court documents, Radulovich became frustrated with the boy's fussiness and, in a moment of anger, handled him roughly. Initially, he provided conflicting statements to authorities, but later confessed to acting impulsively. An autopsy confirmed that Butler died from head trauma.
Do you understand your charges?
Yes, ma'am.
And do you understand the penalties?
Yes, ma'am.
Following the investigation, Radulovich was charged with felony murder and first-degree child abuse, both carrying the potential for life imprisonment. During his court appearance, he maintained his innocence while his defense requested mental health treatment.
The court should be aware that he is requesting some counseling and treatment for mental health disorders that he's currently suffering. We would ask that to be considered as part of his bond.
However, the judge denied bond, emphasizing the seriousness of the charges. The Kent County Prosecutor's Office described such cases as rare, often involving individuals close to the victim, such as caregivers or family members.
And generally, unfortunately, it's, these types of cases are someone that's close to the child, a caregiver or a guardian, a family member. We don't see these types of charges. In fact, we can't even charge a child when it is a stranger.
As the case progressed, Radulovich entered a no-contest plea to second-degree murder and abuse. Subsequently, a Kent County judge sentenced him to 31 to 100 years for the murder charge and an additional 6 to 10 years for abuse, with both sentences to be served concurrently. Grand Rapids resident Justin House was convicted in the fatal shooting of Jamarian McCullough. The incident began when House discovered that his father's car had been stolen. Instead of contacting the police, he decided to take matters into his own hands. Armed with a concealed pistol for which he had a license, House pursued the suspects. Upon locating the stolen vehicle, House chased the boys on foot. As they fled, he fired his weapon, McCullough in the back. Prosecutors argued that House's actions were not in self-defense and accused him of attempting to cover up the shooting. They presented evidence suggesting that after the incident, House placed his firearm in his car's glove box, changed out of the tan coat he was wearing at the time, and falsely reported the weapon stolen. House initially claimed he suspected one of the boys was armed, though he later admitted he never actually saw a weapon. Prosecutors asserted that his actions were not justified, as McCullough and the other suspects were running away and posed no immediate threat.
You will hear the defendant say that he never saw any of them with a gun, but that at one point he thought one of them who was wearing a red coat at the time, may have had a gun. He didn't see it, but based on the gesture that he was making near his pocket, he thought it might have been a gun.
The defense argued that House acted in self-defense, maintaining that he was nearly struck by the suspect's vehicle moments before the shooting. Witnesses testified that some of the boys may have been armed, supporting House's claims of feeling threatened.
You will hear from Christian Bethea Jr. Mr. Bethea was one of the cars that was parked at the intersection of 20th and Ratcliffe that the driver of the Honda crashed into. You will hear Mr. Bethea tell you that he saw that all the kids that jumped out of the car were armed with guns as they were running.
During the trial, surveillance footage of the shooting was presented as evidence. The jury ultimately found House guilty of second-degree murder and a weapons charge, rejecting his self-defense claim. He was sentenced to 14 to 40 years in prison for the murder, with an additional 2 years for the firearm charge, to be served consecutively. The murder of Susana Alvarado in Westport has remained a mystery for years, but recent advancements in genealogical DNA technology have led to a breakthrough in the case. Alvarado's body was discovered along Route 88 in Westport, Massachusetts, and forensic analysis revealed she had been a victim of violent crime.
The medical examiner determined that she was strangled to death.
Despite extensive efforts, investigators were initially unable to identify a suspect due to the lack of matching DNA in the state's database.
Othram was able to build a comprehensive DNA profile of an unknown suspect, and that was used to conduct genealogy research that provided investigative leads to law enforcement. It allows us to potentially identify someone. It's really a forensic tip, if you know what I mean, that into the case that can lead you to the potential suspect or individual who committed the crime. So that's what happened in this case.
With the introduction of advanced forensic methods, authorities partnered with a Texas-based company to create a comprehensive DNA profile from evidence found on Alvarado's clothing. This new technology provided crucial leads that eventually identified Simão Farias, a 62-year-old resident of New Bedford, as the suspect. Following his indictment by a Bristol County grand jury, Farias was charged with Alvarado's murder.
How do you plead to this indictment? Guilty or not guilty?
Not guilty.
He pleaded not guilty in court and remains in custody without bail, awaiting further proceedings. Law enforcement officials have expressed optimism that the case's resolution will bring a sense of relief to Alvarado's loved ones.
But I think when investigation results in someone being charged, certainly the family is certainly relieved and very pleased with that.
This case is part of an ongoing effort to solve long-standing crimes using modern forensic advancements. Authorities continue to explore the potential of genealogical DNA technology to uncover the truth behind other unsolved cases. Brooklyn Davis, a Grand Rapids mother, is facing serious charges related to the well-being of her daughter and son. She has been charged with felony murder and child abuse following the passing of her daughter, Sky Swope. Authorities have also filed additional charges concerning her son, who was found to be in concerning health conditions. The case came to light when investigators discovered that Sky Swope had experienced severe neglect, leading to significant health concerns. Reports indicated that the home environment showed signs of long-term neglect, with conditions that raised alarms among authorities. Sky's twin brother was found in a similarly concerning state, displaying signs of malnutrition and health complications that required medical attention.
Severe malnutrition with a pretty tremendous amount of weight loss over time since the last time he had been seen by someone in our hospital system. He had kidney injury and then he had some mild liver injury as well.
During court proceedings, Davis remained composed, showing little emotion as the charges were presented. She is currently being held in the Kent County Jail, awaiting further legal proceedings. Luis Talamantes Romero had a long history of criminal activity and repeated illegal entries into the United States. His first documented arrest occurred in 2003 for illegally re-entering the country after deportation. In 2006, he was removed from the U.S., but he soon returned unlawfully. Between 2007 and 2009, his offenses escalated, including domestic violence, jail escape, battery, DWI, telephone harassment, aggravated assault with a deadly weapon, and multiple firearm-related charges. Despite multiple arrests, his criminal behavior continued to worsen. In 2015, he was again caught entering the country illegally after a prior felony conviction and was deported.
Judge, I would like to start by going through the defendant's, his criminal background. Starting in 2003, he was arrested by the feds for illegal re-entry into this country, and he was deported in 2006. That's notable, Judge, because he does have a history of coming back into this country and committing crimes once he is back in the United States. Starting in 2007, he began a string of domestic violence cases. One June 27, 2007, August 31st, 2007, he was charged with escape from jail. February 22nd, 2008, he was charged with a DWI, concealing ID, reckless driving. On April 6th of 2008, he was again charged with battery on a household member. April 12th of 2008, he was charged with telephone harassment. And then in 2009, the victim of those previous domestic violences, sometime before 2009, took out an order of protection against him. Subsequent to that order of protection, he was charged with 4 separate counts of violating that order of protection and an aggravated stalking case, an aggravated stalking charge. In 2009, he was charged with aggravated assault with a deadly weapon and a firearm enhancement. He was also charged in 2009 with a second aggravated assault with a deadly weapon, a false imprisonment, receiving, transferring a stolen vehicle, conspiracy to commit, receiving, transferring a stolen vehicle, and receiving a stolen firearm. On February 3rd of 2009, he was charged with a commercial burglary and a larceny and criminal damage to property. On February 11th, he was charged with an aggravated assault with a deadly weapon and a firearm enhancement. Also charged that same case with shooting at a dwelling or occupied building and shooting at it from a motor vehicle. He was charged in 2006 federally for entry into the country and was removed in 2012.
You said that was, 2006?
Yes.
Okay.
He was removed from the country. So there was a federal arrest. It doesn't appear that he was removed until 2012. So I'm not sure what the procedural history there was. In Colorado in 2015, there was a misdemeanor arrest for a false report. In 2015, he was charged with auto burglary. In 2015, he was charged federally with an illegal reentry of a removed alien subsequent to an aggravated felony, and he was removed from the country. He came back into the United States, and on November 19th of 2019, which Your Honor is aware, is when he murdered Jackie B. Hill. The federal government charged him subsequent to Jackie's murder, again with illegal reentry. In 2021, he was investigated for a larceny of a firearm and an aggravated burglary. And in 2022, October 29th of 2022, he was charged with possession of methamphetamine and Suboxone while he was in custody on this case. Judge, this defendant has an extensive violent history. His history shows a progression of his crimes, starting with misdemeanor domestic violence, ramping up into possessing firearms, using firearms, shooting firearms, conspiracies, and arrests and charges, being deported, receiving prison time in some of those instances. None of that was a deterrent leading up to Jackie's murder. Despite being arrested over and over, nothing stopped him.
However, he re-entered the U.S. yet again, continuing his pattern of lawlessness. On November 19, 2019, he committed a burglary in Albuquerque, New Mexico. When confronted by witnesses, he pulled out a firearm and threatened them, showing no hesitation in using intimidation to continue his crime. Shortly after, he approached 55-year-old Jackie Vigil, who was sitting in her car outside her home, getting ready to leave for the gym. Without warning, he shot ladder, killing her instantly. Jackie, originally from Colombia, had become a proud American citizen and was known for her kindness and generosity. Her sudden death devastated her family and community.
The burglary that this defendant committed, that he's been convicted of just before he murdered Jackie, shows a brazen attitude. The testimony in this trial was that he brandished his weapon and even pointed it at his victims as they came out on the balcony, catching him in the act. He was undeterred, and that's sort of part of his pattern. He didn't stop burglarizing their vehicle or run away. He instead pointed his firearm at those victims to scare them off and continued about his crime. This jury found him guilty of a premeditated, willful, and deliberate murder. He went up to Jackie, sitting in her car, put his gun up to her head through her window, and executed her. She was what can only be described as a truly innocent victim here. She wasn't doing anything. She didn't provoke anything. She's literally just trying to have some fruit and go to the gym in the morning. You heard from other witnesses in this trial, notably Carla Arguiri, told you that he was not remorseful or even overly emotional until he began to fear being caught. Once he realized who he had killed, that her sons were state police officers, when it was on the news, when his vehicle was on the news, that's when he started to get worried. And his worry escalated into threatening her and into fleeing the state, and eventually with a plan to flee the country. He utilized his family, and we heard jail calls, to help him cover up the crime, to dispose of the used, and to dispose of the car that was so distinct in this case.
After the murder, he showed no remorse and instead focused on covering his tracks. He enlisted family members to dispose of the murder weapon and the car used in the crime. As news reports about the killing spread, he became anxious and began planning his escape, discussing ways to flee the country. Despite these efforts, law enforcement captured him, ending his crime spree. In 2021, he was convicted of first-degree murder for killing Jackie Vigil.
Discretion as far as how I'm sentencing Mr. Talantes Romero. He has already been convicted on the charge out of Texas, so I think once we're done here, he's actually going to be transported back there where they're going to have primary jurisdiction, so he's going to serve that count first. I'm also not going to be able to run this concurrent to that charge, and so he's not going to come back to New Mexico until he's done serving the sentence, because I can't wait for him to be sentenced there before transferring back here. I don't think anybody's asking for that. So what I'm going to do, I'm going to run some of these concurrent, but most of the way that I'm structuring this is thinking about the charges that ran together, the events that ran together, and then not necessarily looking at this as murder, but looking at this as each event, which I think deserves a different sentence or a different punishment for each of them. The charge that will run first will be the first-degree murder. That's count 1. For willful and deliberate. I will vacate the felony murder conviction, which was an alternate to count 1. I will then have him serve the aggravated burglary, which is 9 years plus the firearm enhancement. That will run concurrent to count 5, which was the attempt to commit armed robbery, and so those two will run concurrently for 10 years. Count 3 will then run next, which is the aggravated battery with a deadly weapon. That's 9 years plus the firearm enhancement of 1 year. He will then serve the conspiracy to commit aggravated burglary with a deadly weapon, which was the conspiracy that he served with Isaac. This is one of those cases where I don't think the conspiracies merged together, because I think that each of them was a distinct act, and so that will run next. Count 5, as I had mentioned, is running concurrent to count 2. Count 6 he will then serve his sentence on count 6, which will run concurrently with count 6 is the tampering with evidence for either dismantling the firearm or cleaning and dismantling to an extent the gold Jeep Cherokee. Those two charges, or that charge, will run concurrently with the conspiracy charge, so that will run concurrently for 3 years. And the final charge is the larceny charge. And I think that one is actually just 6 months as opposed to 6 months minus 1 day, because it is a petty misdemeanor. So the way that I count it will be he'll be serving 26 and a half years after he does the life sentence for first-degree murder charge. Anything further from the state?
Just to clarify, Judge, count 5 will run concurrent to count 2, and count 6 will run concurrent to count 7?
Yes.
Okay, and your Honor is not finding merger, you're just running those concurrent?
Yes.
Okay, understood.
Given his history of violent offenses and repeated illegal entries, he was sentenced to life in prison plus an additional 25 years, ensuring he would never be released. Jackie's murder was a senseless act of violence committed by a repeat offender who had been deported multiple times, yet continued returning to the U.S. to commit more crimes. Her family found relief in knowing justice had been served, though her loss remains an irreplaceable tragedy. Natalie Cochran, a pharmacist from West Virginia, spent years deceiving investors with promises of lucrative government contracts. Between 2017 and 2019, she orchestrated a $2 million Ponzi scheme, using the funds for personal luxuries, including expensive real estate, jewelry, and a 1965 Shelby Cobra. She convinced people to trust her, all while diverting their money to maintain a lavish lifestyle. As time passed, cracks in her scheme became apparent. Her husband, Michael Cochran, began noticing financial inconsistencies and questioning their business dealings. Fearing exposure, Natalie administered a fatal dose of insulin to him in February 2019. Despite his rapidly deteriorating condition, she delayed seeking medical attention. 5 days later, Michael succumbed to the poisoning. For a time, she managed to avoid consequences. Authorities initially investigated his death but lacked the evidence to charge her. However, her fraudulent activities did not go unnoticed. In March 2021, Natalie pleaded guilty to wire fraud and money laundering and was sentenced to 11 years in federal prison. While serving time for financial crimes, investigators continued gathering evidence against her, leading to her indictment for first-degree murder in late 2021.
We have the only evidence the state has presented to this court is that at some point my client had in her possession an insulin which we know cannot cause the type of reaction that has caused, in this case, to the alleged victim. We know that my client was perhaps a fraud and a cheat, but we have no motive, and I understand that the motive is not usually considered by the courts in arriving at the decision. Motive for this defendant to kill her husband, and the state produced none. The state admitted to having no direct evidence, but the state cannot even produce circumstantial evidence. If we had circumstantial evidence of the substance that killed Mr. Cochran, we would perhaps not be making this motion. But we don't have that evidence. All we have is a vial of insulin, full and seemingly untouched, even though there seems to be a puncture in a bottle of this insulin that, as stated by the government's experts, cannot kill this victim. What's more, the state's star witnesses, well, at least Dr. Krieger testified that death by insulin is probably one of the reasons, maybe, but we don't know. Then Dr. Uribe stubbornly refused to admit that that there are other possibilities. We have the evidence of the alleged victim being a man of extremely questionable health, and we don't have a murder weapon. We don't have the motive. We don't have the insulin that may have been used. We have a couple of contradictory theories. First, it was the insulin in the morning in the kitchen. Then it was perhaps insulin in the bed. Then it was the insulin perhaps on the couch. These are all guesses. These are all suppositions. These are all innuendos. Then we have insulin that was administered in the morning. Then we have the theory that it was administered later on that afternoon. And that was the evidence that it would have to be continuously administered to cause the death. We have the evidence that this man, even if injected, would have been alive for 15 to 30 minutes to seek any type of help, assistance, aid, or comfort. He didn't do that. We don't have the evidence, direct or circumstantial, that Natalie Cochran killed her husband. And for that reason, I'm asking the court, well, the only evidence that potentially could be brought before this court is some evidence that the state argued for Mr. Cochran not to be taken to the hospital immediately. But that's the evidence of perhaps involuntary manslaughter. Negligent homicide, perhaps. That's a misdemeanor. That's not first-degree murder. Premeditation, when the defendant calls for a murder weapon on the same day and pretty much tells everybody, at least 2 witnesses, I want to kill my husband. That's the evidence. He might have just as well asked for a gun, for a murder weapon. That's not the evidence that the state can hang his hat on. There's no evidence of premeditation. There's no evidence of deliberation here. And for that matter, there is no evidence of malice. And we have also the evidence of no evidence of what Mr. Michael Cochran would have done had he learned about this alleged fraud. We have no idea what he would have done, and therefore there is no evidence that my client needed to kill him for anything.
During her 2025 trial, the defense attempted to have the case dismissed, claiming there was no direct or circumstantial proof linking Natalie to the murder. They pointed out inconsistencies in the prosecution's timeline, argued that Michael had pre-existing health conditions, and insisted there was no clear evidence that she administered the insulin. The prosecution countered that her motive, access, and opportunity made her guilt undeniable.
Thank you, Your Honor. Well, we do agree with the defense that the state does not have to prove motive, although there is evidence of motive. Aside from that, the state's made a prima facie case, and that's all we have to do at this stage. The circumstantial evidence is significant, overwhelming, and a reasonable jury could use it to convict this defendant. That's what they should do, based upon the state of the evidence. The defense has floated a lot of smoke out there, but at the end of the day, when this man went to Raleigh General Hospital, he had a blood glucose of 21, and our experts accounted for that by him being injected with insulin. That's enough. She had motive, she had opportunity, she had the means to do it. She's a diabetes counselor. She's a pharmacist. Putting all that together, there's more than enough evidence to convict. Thank you.
Thank you, Mr. Truman. The court notes that the state told us all that this would be a circumstantial case. We've heard from significant witnesses, and perhaps the most important one in the court's mind was Dr. Uribe, who testified that the only way this victim could have died would be from insulin. We have heard about a motive that the defendant may have had to proceed in this manner against her husband. The court believes that a prima facie case has been established here, sufficient enough to take the case to the jury. The court is therefore constrained to deny the defendant's motion for judgment of acquittal, and I'll preserve this matter fully for the possibility of a review on appeal. All right, the next item we have to do, I have to advise the defendant of her Newman rights. I have to discuss with her right to testify in her own behalf in this case. For that purpose, we'll have to clear the courtroom of the state and all parties associated with the state, and also I would ask to clear out the media as well, because this is a very private matter, and all parties that are here to observe as well.
However, prosecutors argued that her actions were deliberate, designed to keep Michael from uncovering her financial crimes. They presented medical evidence confirming insulin and highlighted how Natalie, as a pharmacist, had the expertise and access to carry out such a plan. Experts testified that Michael's symptoms aligned with insulin overdose, strengthening the case.
In the case of State of West Virginia versus Natalie Page Cochran, case number 23-F-343K, the jury verdict is as follows. We, the jury on the issues, joined unanimously find the following. The defendant is guilty of murder in the first degree. The verdict form, there are no marks on the portion of the verdict form pertaining to involuntary manslaughter. Does the state wish to examine the jury verdict form?
Thank you.
Does the defense?
No, Your Honor. Thank you.
You may be seated. Is there a request for the court to poll the jury?
Not from the state, Your Honor. No, Your Honor.
All right. The verdict is received by the court and directed to be recorded. I'll ask the state to prepare an appropriate order in the premises. The court accepts the jury verdict and finds this defendant guilty of murder in the first degree.
The jury found Natalie guilty of first-degree murder on January 29, 2025. She was sentenced to life in prison with eligibility for parole after 15 years. The verdict provided a sense of justice for Michael's family, who had long suspected foul play. Alex Murdaugh was once a respected attorney in South Carolina, part of a powerful family that had dominated the legal landscape for generations. Beneath the surface, however, he was deeply entangled in financial misconduct, stealing millions from his law firm, clients, and even the family of his late housekeeper, Gloria Satterfield, who had died under mysterious circumstances at his home in 2018. In February 2019, Murdaugh's son, Paul, was involved in a tragic boating accident that resulted in the death of 19-year-old Mallory Beach. Paul had been driving the boat while intoxicated, and lawsuits quickly followed, bringing unwanted scrutiny to the Murdaugh family. As legal pressures mounted, so did the cracks in Alex Murdaugh's carefully crafted image. On June 7, 2021, Murdaugh called 911 to report that he had discovered the bodies of his wife, Maggie, and his son, Paul, to death on their family estate in Moselle, South Carolina. The double homicide shocked the community, and while Murdaugh was initially seen as a grieving husband and father, suspicions began to rise as investigators dug deeper into his past. 3 months later, in September 2021, Murdaugh orchestrated a staged roadside shooting, hiring a former client to shoot him in an attempt to make it appear as though he had been attacked. He planned to secure a $10 million life insurance payout for his surviving son, Buster. The scheme failed, leaving him with only minor injuries. Soon after, he admitted to the plot, further unraveling the deception that surrounded him. As investigations into the murders continued, authorities uncovered extensive financial fraud. It was revealed that Murdaugh had embezzled millions from his law firm and clients, including money intended for the family of his late housekeeper. His once powerful reputation crumbled under the weight of these revelations. In July 2022, he was indicted for the murders of his wife and son. Prosecutors argued that he had killed them to distract from his financial crimes, which were on the verge of being exposed. The trial began in January 2023. Evidence presented in court included cell phone records, gunshot residue, and a crucial Snapchat video recorded by Paul just minutes before his death, which directly contradicted Murdaugh's alibi. After weeks of testimony, on March 2, 2023, he was found guilty of both murders. The next day, he was sentenced to 2 consecutive life sentences without the possibility of parole. Following his murder conviction, Murdaugh also faced numerous charges related to financial crimes. In November 2023, he pleaded guilty to 22 counts of fraud, money laundering, and embezzlement. During his financial crime sentencing, his former friend and victim, Jordan Jinks, delivered a powerful and emotional statement.
I've been waiting on this day. I've been waiting on this day to look in your eyes. I wanted to sit down with you one-on-one. When I found out what you did, I just want to know why. I can sit here all, excuse me. Unlike a lot of these people here, these victims, I got a lot of intimate stuff that I could say. You remember all those wildlife hunts I had for law enforcement? Your entire family was the guest of honor. Mr. Buster, Judge Eldroff, insisted on me taking care of them for the day. You don't know how many brownie points you got in my life from just that. I trusted you with everything. I knew I was gonna break. I knew it.
Mr. Bland, can you reposition his mic so I can understand?
I knew I was gonna break. Excuse me, I knew I was gonna break. But I got some notes here I don't even know if I can go through. Our family got a deep relationship, man. You remember making a comment to me after I found out, after we discussed the possible amount this lawsuit was worth, and you made a comment to me, and you said, don't spend all this money foolishly. Tell me what you did with $20 million that you stole. Part of it being mine. And you know, I'm sitting there crying. I want everybody to, Judge, I need you to know. I'm not crying because of what he stole from me. I'm crying for what he did to everybody in the suit. These kids, these people dying. I didn't want to come up here and bash you, but I gotta ask you, what kind of animal are you? I can't even go over my notes. I'm not here to be your judge. Ultimately, that belongs to the good Lord and Savior. But may He have mercy on your soul. I didn't want to see you. When I saw you on TV in an orange jumpsuit, it hurt me. Still wasn't mad at you. But this judicial system put together a system to deal with people that make bad choices. And my friend, you chose to make the choice you made. So I need the judge to know that I am in full favor of the court's recommendation for the 27 years. I can go back to us going to mediation. That you affected my wife. You chose to have Maggie deal with us those 2 days we were in Charleston in mediation. She catered to us hand and foot. You told me where to go and check into my room. We did. From that point, we never drove another foot. Neither did you. Maggie drove us everywhere we went. When all this came about, Paul, and Maggie, I couldn't believe it. I didn't believe it. But after sitting here today and hearing some of the devious things that you did to people, these victims here, changed my mind, bro. Once again, I ask you, what kind of animal are you? Boy, I gave you my all. I would do... The money you stole from me, you could have asked me for it and I would have gave it to you if that's how I felt about you and your family. You didn't have to steal it from me, man. And I still, if there's any way possible, you set it up for me to be on your visitation list. I want to sit down with you. I want to look you in your eyes and talk to you when I can really talk to you. We got some intimate things we can talk about.
I would like that.
But why, bro? Why? Such a talent. Do you know what you just threw away? You know how talented you are? I don't understand. Mr. Harpoonian, nothing to do with you, but you made a comment earlier about the attorneys trying to sell bobbleheads and cups. Can you represent this man to sell those bobbleheads and cups to repay the victims that he stole from?
Jinx recalled their past friendship and the trust he had once placed in Murdaugh, expressing profound disappointment and betrayal. He questioned how someone could steal from those closest to him, and wondered what kind of person could commit such devious acts. Though devastated, Jinx fully supported the court's decision, believing justice had been served.
I take no joy at all in imposing this sentence, but it is what it is. And you'll have to suffer the consequences of your acts, continue to suffer the consequences. And hopefully some good will come out of you as you move forward. There are a number of counts here, a number of indictments, and you'll get an individual sentence as to each one. On indictment, GS 4727, for money laundering, the sentence is 20 years. Obtaining signature of property by false pretenses, the sentence is 10 years. The second count of obtaining property by false pretenses, count 7, 10 years. A breach of trust with fraudulent intent, value more than $10,000, the sentence is 10 years. Another, obtaining property by false pretenses, count an indictment 4730, count 4, sentences 10 years. Money laundering on indictment, same indictment, count 5, sentences 20 years. Money laundering, count 8 of that indictment, the sentence is 20 years. Breach of trust with fraudulent intent, indictment number 32, count 1, sentence is 5 years. Money laundering under indictment number 33, count 2, the sentence is 20 years. Money laundering under indictment 34, count 2, the sentence is 20 years. Forgery, value $10,000 or more under indictment 35, count 5, the sentence is 10 years. Computer crimes under indictment 36, the sentence is 5 years. Breach of trust with fraudulent intent under indictment ending in 37, the sentence is 10 years. All those sentences will run concurrent with each other. Money laundering under indictment ending in 38, count 2, the sentence is 7 years consecutive to sentences previously stated. Under indictment 01, 4701, breach of trust with fraudulent intent, the sentence is 10 years concurrent. Breach of trust, fraudulent intent under indictment ending in 02, count 1, sentence is 10 years. Under indictment ending in 10, count 1, sentence is 5 years concurrent. Money laundering in indictment ending in 23, count 3, the sentence is 20 years. Under indictment ending 24, obtaining goods under false pretenses, sentence is 10 years. Willful intent to evade or defeat payment of taxes under indictment 34, sentence is 5 years concurrent. You have one 20-year sentence and a consecutive 7-year sentence for a total sentence of 27 years. Most of the offenses pled to are serious offenses under the law. Subjects you to the 3 strikes law. You are given credit for time served pursuant to section 241340 to be calculated by the South Carolina Department of Corrections.
The judge emphasized that Murdaugh must face the consequences of his actions, acknowledging the gravity of his offenses. Murdaugh was sentenced to 27 years in prison for money laundering, fraud, and breach of trust, and more, with most sentences running concurrently, except for one 7-year term ordered to run consecutively. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.